So let's talk about the very first major event that occurs after you request a hearing. As you may know, after you receive your report of investigation or your investigative file, you request a hearing from an administrative judge. You may have a long limbo period from the time you request a hearing until you receive your first major order from a judge, setting down conferences and deadlines. This order is called an acknowledgment. Sometimes it also is an order that schedules the initial conference, where you will have an initial conference to speak with the judge and the agency attorney regarding many important things. This acknowledgement actually acknowledges receipt of the hearing request, and some orders, and depending on your jurisdiction, it will schedule an initial conference to talk about very important items. This is a sample of the laundry list of items that you can prepare for during your limbo period while you're waiting on this order. These are the things that you should be prepared to discuss once that order comes through, and you definitely should be prepared to discuss it at the time you have your initial conference with the judge, including amendments to complaints, which is very important because your case may have been dismissed partially or it may not have been framed correctly, and you need to address that. You also need to address discovery. You need to have a discovery plan, and I will discuss that in more detail shortly. You should also be prepared to discuss settlement. And so that's something that the judge will ask the parties about. And so the order will talk about amending your claim. For instance, if you had a claim that was partially dismissed, now is the time to raise that with a motion. The judge will also talk about settlement. So we talked about that earlier, that settlement is something that you need to be realistic and flexible in your approach on. The judge usually reminds the complainant or the plaintiff that a large percentage of cases are actually decided on a motion for summary judgment in favor of the agency, and not after a hearing. So even though you've requested a hearing, you may not actually make it to a hearing if the agency succeeds in a summary judgment motion. So you have to keep these things in mind when you're making a settlement demand. Discovery. Let's talk a little bit about what discovery is. Discovery is something that is a mechanism whereby the parties use interrogatories, admission requests, or you request documents, or sometimes depositions, basically to further develop the record. All right, so you're going to want production of documents. You're going to want things that are not already in the investigative file. If you need more testimony, you're going to want depositions. Remember, the other side, the agency, is going to engage you in discovery as well. So you want to do the same, and it has to be relevant to your claims, and it's usually less than a 90-day period for discovery. Before I go back through the rest of this order, this sample of an order, I want to talk a little bit more about discovery here. So there's interrogatories where you're going to ask questions such as list all the possible witnesses, anything that may come up. And then there's document requests. You're going to want to request things that are not already contained in the ROI. It's very important to request documents to avoid unfair surprises. Again, the ROI, the report of investigation, it's a great tool because it'll allow you to see that there may be some holes. There may be some things that need to be filled in terms of evidence that will help support your case. And you want to avoid unfair surprise at trial. So you want to make sure that you tailor your request so that you get documents and so that there are no surprises at the final trial. And it also helps you assess your case. So there's document requests. There are many types of discovery tools. We just I just showed you a few interrogatories. I just showed you a few requests for production of documents. Um, so again, the order will talk about sanctions. Sanctions basically means punishment. If you fail to follow the judge's orders, and this is why it's important to get an attorney around this time frame, because if you fail to follow the orders, one of the sanctions could include dismissal of your case or a denial to a right of a hearing. And judges do impose that. If you miss a deadline or if you do not follow the letter of this order, your case could be dismissed. And so that is an overview of what you can expect when you receive this order in the mail. It's important to prepare for this order ahead of time. Feel free to give us a call if you have any questions.